Now I want to just have a little heart-to-heart talk with you, if I might. I come at the subject...
Just you and me.
Just you and me and nobody else.
Don't anybody in the room listen.
I come at the subject of guns probably differently than most of my colleagues. I think I've seen too much. You know, I wrote the assault weapons legislation. I found the body of Harvey Milk. I became mayor as a product of assassination. I've watched as innocent after innocent has been killed, the latest of which in my state is 2 weeks ago, a 6-year-old in a Spider-Man costume eating an ice cream bar in the kitchen was killed by a bullet coming through the room. I can show you in Los Angeles where a woman ironing killed the same way. A youngster playing the piano killed the same way, bullet right through the walls, is paraplegic today. Now, you answered Senator Leahy's question that you believe that both Heller and McDonald are binding precedent and entitled to all respect to binding precedent in any case. That is settled law, you said. Okay. This is a 5-4 closely decided decision in both cases. California is not Vermont. California is a big state with roiling cities. It's the gang capital of America. The state has tried to legislate in the arena. As I understand, McDonald, it's going to subject virtually every law that a state passes in this regard to a legal test. And that causes me concern because states are different. Rural states have different problems than large metropolitan states do. I mean, we probably have as many as 30 million people living in cities where the issue of gangs is a huge question. So here's my question to you. Why is a 5-4 decision in 2 quick cases, why does it throw out literally decades of precedent in the Heller case in your mind? Why do these 2 cases become settled law?
Senator Feinstein, because the court decided them as they did. And once the court has decided a case, it is binding precedent. Now, there are various reasons for why you might overturn a precedent. If the precedent proves unworkable over time, or if the doctrinal foundations of the precedent are eroded, or if the factual circumstances that were critical to why the precedent, to the original decision, if those change. But unless one can sort of point to one of those reasons for reversing a precedent, the operating presumption of our legal system is that a judge respects precedent. And I think that that's an enormously important principle of the legal system, that one defers to prior justices or prior judges who have decided something, and that it's not enough, even if you think something is wrong, to say, oh, well, that decision was wrong, they got it wrong. That the whole idea of precedent is that's not enough to say that a precedent is wrong. You assume that it's right and that it's valid going forward.